Hi, and welcome to this immigration law conversation. In these informal conversations, I discuss with people current issues of law that are affecting us. These are not meant to be advice on particular cases, but this is an informal discussion which we hope will be informative and helpful to you. Today, I'm with Gary McIndoe from Latitude Law in Manchester, and we're going to talk about indefinite leave to remain applications on the basis of 10 years residence in the United Kingdom and some common problems we face. So Gary, thanks for coming on today. What sort of casework do you do on a day-to-day basis?
We at Latitude, we do the full range of immigration work from asylum through to PBS and sponsor licensing. So, you know, it's a very varied diet. I've been practicing in this field for donkey's years. I just remembered actually this morning, I reached my 20 years of qualification during lockdown, and it went unnoticed by anybody. So
well congratulations on your work anniversary. That's fantastic. And we've seen a lot of changes changes are constant for us as immigration lawyers. In terms of indefinite leave to remain applications, particularly under 276B and the 10 years continuous lawful residence in the United Kingdom, what are common sort of issues and problems you're finding that clients are facing at the moment?
Okay, well, there are two kind of aspects to the continuous lawful residence rules and the guidance that attends them. The first really is in relation to actual physical presence in the UK, and that's more straightforward, really. You know, the rules say you're allowed 6 months out at any one time, or 18 months abroad cumulatively in your 10-year qualifying period. So, you know, there's a few kind of bells and whistles on that. You know, the guidance makes clear that, for example, if you leave the UK with valid leave and you then come back with a different grant of leave in a different capacity, that's fine. You can hit problems if you leave the UK having overstayed and you don't then make an application within a 28-day period, but that's kind of less common. So we don't really see problems with, you know, actual physical presence beyond. I suppose it most commonly arises with students, you know, who've been here in, you know, tier 4, and then they might have moved into sponsored work later in their 10-year qualifying period. Quite often students, younger students especially, have spent quite significant periods outside the UK when they were younger, you know, because obviously the school or the college is closed and they've not been able to stay in the UK during the vacations. So, you know, they might have a much higher level of absence from the UK than they need. So that person might then have to wait a little while in their sponsored employment or whatever before they become eligible for indefinite leave to remain under the 10-year route. So that's reasonably straightforward. Doesn't sound particularly straightforward what I just said. Sorry, but you know, it's a question of degree, really. And when you compare it to the question of continuous lawful residence for somebody who's remained physically present in the UK but may have made a late application for leave, may have overstayed slightly, may have gone through an appeal and then subsequently been granted leave following an appeal, that's when problems really start.
Let's before we get to the problems, let's just get in relation to that continuous residence and time spent outside the United Kingdom. Obviously, there's provision in the guidance, and when Gary and I talk about the guidance, we're recording this at the end of May 2020, still during lockdown. The current Home Office long residence guidance, and I'll put a link below the video, is version 16. And it's the 28th of October 2019. Gary, there is within that a sort of discretion for exceptional circumstances in terms of gaps, in terms of time outside the UK that is longer than permitted. How do you find the Home Office in terms of applications? I've just done a JR grounds on somebody who went for work purposes, planned to come back within the time, but then got significantly ill while abroad, and his gaps then, time outside the UK became too long, and affected his ILR application. How do you find them exercising discretion in those circumstances?
Yeah, I think you'd expect discretion to be exercised in that kind of situation. Where it's purely work-related absence, that's when you start hitting problems, I suppose. Although not really in this category, but in other categories, the Home Office has come to kind of recognise now in its rules and guidance that, you know, for example, academics, you know, who need to do field work abroad, you know, that those kind of absences are permissible when someone's looking to qualify for ILR. It's not written into the long residence guidance yet, but you know, that's the way it's kind of going. I think, you know, there's more of an acceptance of the demands of people's jobs taking them abroad, you know, and that person might well still be able to qualify for settlement at the end of a 10-year period.
Yeah, I did a case years ago. It's reported as a case called BD, and that was about gaps because of work placements abroad, and people may, in ILR claims, be able to use that by analogy. It wasn't a long residence case, it was a work permit ILR case, but still may be useful by analogy. And again, I'll put the link below this video. Then you went on to it harder, those perhaps who've got in the UK and they've had gaps in their lawful residence, they've become overstayers. Perhaps first, let's have a look at, if you're an overstayer, you've got your 10 years in the bank, but you're an overstayer at the time you make your ILR application. What about that? You know, you can apply as an overstayer within the 14 days within Rule 39E, but obviously you have to have your 10 years in the bank. The case of Ahmed from the upper tribunal tells us. So yeah, we can apply as that. What about gaps? What about gaps in the period of the 10 years, gaps of short periods of overstaying?
So the way the guidance worked and the rules worked so this is for leave pre-November 2016, was that there was a kind of a general grace period of 28 days which applied to all cases. So if you'd applied late or you've overstayed for some other reason, then this 28-day grace period would be applied, and you'd generally be okay. From November 2016, immigration rules changed, and that 28-day grace period was reduced to a 14-day, and it's not really a grace period anymore, because the Home Office now wants to see reasons, or good reasons, why you've applied late or you've overstayed for that 14-day period before making a new application. So the guidance continues to reflect that approach to short periods of overstaying, short breaks in lawful residence you know, for the purpose of long residence applications. But the courts have taken a different view.
Yeah, absolutely. Some people may have seen my previous video about the Court of Appeal case of Ahmed, which is 2019 EWCA Civ 1070. And in that case, the Court of Appeal found it's only a permission decision, but the Court of Appeal reported it to give guidance on the issue, that this can't be relied upon. So Roman 5 of 276B can't be relied upon. So where you had those previous gaps that within the 28 days, or within the more narrow 14 days after November 2016, they can't be relied upon to establish the 10 years, which for a lot of us immigration practitioners left us scratching our heads, because that was the whole purpose of the rule. And the Home Office still continue to have the guidance allowing for this. Now, I understand these cases are being challenged further in different cases in the Court of Appeal, but how are you finding, say you've got a client now who's making an application to the Home Office, who had one of these, I'm going to call them permitted gaps, had one of these permitted gaps within that period. Are you finding the Home Office are still granting them? Are they following their policy, or are they following the court?
Unfortunately, from our perspective and from our client's perspective, results are variable. We've had cases granted, and we've also had cases refused. So it's very difficult at the moment for practitioners, I think, to give clear and certain advice to potential long residence applicants who've got a break in their lawful residence. I think it's kind of interesting, isn't it, that the current guidance from 2019 post-dates the court's decision, the Court of Appeal decision, and there was an earlier upper tribunal decision as well, a judicial review, which said pretty much the same thing. And there's no mention of those in the guidance whatsoever. So the Home Office, on the one hand, has this published guidance on the gov.uk website. On the other hand, it's still arguing a different position in litigation, as far as I know.
It would be interesting to see if somebody got refused in an application following Ahmed. Obviously, the right of appeal would be a human rights appeal, because a long residence refusal is considered a refusal of a human rights claim. Could you argue in a human rights claim that they haven't followed their own policy guidance and that renders the decision disproportionate?
Yeah.
I suspect some judges will say, get lost, we're following Ahmed. Others may be sympathetic, given that the Home Office have this policy.
Yeah. The problem you've got there, though, is that if an appeal is allowed on human rights grounds, it then goes back to the Secretary of State to decide what to give that person. And if they give them a 30-month period of limited leave, then that's really, it's not a great outcome for your client, is it? So you're relying then on the Secretary of State granting indefinite leave to remain in accordance with the long residence rule, I suppose, or they might do it outside the rules. That is an option open to the Secretary of State, isn't it? It's certainly what happens with 10-year applicants who've got some EEA residence as part of their qualifying period. Technically, they're granted indefinite leave outside the rules.
Yeah, absolutely. Just for anybody looking, it's page 25 of the guidance, where you've previously had a right to reside under the EEA regulations. That's not technically lawful residence for the purpose of the rule, but the Home Office, their policy said they must consider it, but it is, as you say, a grant outside of the immigration rules. And I suppose the difficulty with this is always cost. In terms of putting aside lawyers' fees, what are the Home Office costs at present for making an indefinite leave to remain application under this category?
Yes, it's over £2,000, isn't it? The application fee. There's no health surcharge to pay, so that's an upside, but it's still quite a significant amount of money, and with lawyers' fees on top, it's a big risk to take, and it's why it makes practitioners like me uncomfortable in when we're advising clients in this situation. I suppose what we can do is prepare and put forward the best possible case, and to go into as much detail as possible in relation to short periods of overstaying. That's going to be relevant if you're refused and you've got a human rights appeal, certainly.
The other thing I was going back to the thing we discussed earlier. If you had these periods where you'd had time outside the UK for too long, what sort of evidence would you want? So you've talked then about preparing a good application in terms of gaps in lawful residence. What about gaps in, or too many gaps in continuity of residence? What sort of evidence would you want from clients in terms of justifying why you spent too long abroad?
Yeah, I mean, one piece of advice I'd always give is, where possible, make a subject access request and obtain disclosure of your client's file from UKVI prior to submitting an application. What the Home Office have said in previous, in response to previous applications, isn't always accurate. We're dealing with a case at the moment where the Home Office say a late application was made, and it's around 2012 or something like that. The GCID records, which are part of the the Home Office file, show that that wasn't in fact the case. It was just it was a misinterpretation by the caseworker at that time. But it just follows through. And 8 years later, you've still got that kind of error in the Home Office decision making. So it's always worth finding out exactly what the nature of your client's immigration history is. And in terms of evidence, it's all fairly obvious stuff, really, isn't it? If you've been sick, you get medical evidence. If you've had work issues which have prevented you from returning to the UK in time, then get a letter from that employer, you know, to explain exactly what your duties were and why, you know, why it was important that you stayed abroad for that period. So, you know, it's not rocket science in terms of evidence, but all that work at application stage is only going to help you if you are refused and you come to an appeal.
Yeah, so things you've sort of said is about front loading the application, sort of referring to the Home Office policy, raising human rights issues, getting the evidence perhaps of any compassionate issues, medical, bereavement, work problems. I suppose now COVID problems that you've been stuck outside a country, you'd hope they'd be sympathetic. And I think that's an excellent guide in terms of getting a subject access request, because often we see clients tripped up by immigration history, but sometimes the Home Office haven't got it right. And if you've got that subject access at the start, it sort of nips those problems in the bud. Just out of interest, putting COVID aside for a moment, how long are you finding that subject access requests are taking at the moment from the Home Office?
We are still receiving them electronically at the moment to a nominated email address within the firm. I mean, it's still taken a couple of months, I think. It's not speeded up any, but at least, you know, they are still functioning at the Home Office. Yeah.
So if somebody's got perhaps a potential issue in their immigration history, rather than wait till 28 days before their leave expires, seek advice early so you can do those preliminary sort of searches in terms of their immigration history to make sure everything is rock solid before you make the application.
Yeah, it's just like, you know, sort of sensible preparation, isn't it? It's like, you know, if you're doing a conveyance, you know, you check, you know, you check the land registry records and you do local searches. It's just a sensible approach, I think, to this kind of work, rather than relying on either what your client tells you or what the Home Office have previously told them. You know.
No, that's brilliant, Gary. Those are really helpful tips, and I think that really gives a good practical way forward on what is now a really difficult area. And I think any, you know, honest representative will always express that difficulty, because there is a clear tension between what the court is saying, what the Home Office is saying, and the decisions we're getting on a day-to-day basis.
Yeah, I think that's right. Yeah, the whole issue of continuous lawful residence, it's not just, you know, it's not just confined to long residence applications either. You know, when people, you know, they get their indefinite leave to remain, they then come to naturalise in a year's time, you hit similar problems again. And the guidance, you know, on naturalisation, it's all considered part of the good character guidance for nationality applications. It doesn't mirror this guidance. So again, you know, care is needed at that stage of an application as well.
Yeah, that it could reverberate not just on the ILR, but even if you get ILR, then something you may have to address, and a different sort of criteria in the naturalisation guidance. Yeah.
Yeah.
No, that's brilliant. Gary, thank you so much for today. As I said, we're recording this at the end of May 2020. There are legal challenges ongoing in relation to this, so do check with your representatives, or if you are a representative, do check on what the Court of Appeal have said in relation to the long residence guidance and 276B. If somebody wants to get hold of you, Gary, what's the best way to get hold of you and your team at the moment?
We're working remotely, moving back towards office-based working during June, we hope. But yeah, just look us up online, latitudelaw.com, and you'll find mine and my colleagues' details on there.
That's brilliant. Thank you so much, Gary. Thank you for your time, and hopefully we'll all get back and we'll meet up in person soon.
Thanks very much, Adam.
All right, all the best.